This is Barry Zalma speaking for Claim School Incorporated's newsletter, Zalma's Insurance Fraud Letter for July 15, 2024. This is not a political newsletter, but as an American, I am happy President Trump survived this evil attempt on his life, and repeat this quote from President Trump. Thank you to everyone for your thoughts and prayers yesterday, as it was God alone who prevented the unthinkable from happening. We will fear not, but instead remain resilient in our faith and defiant in the face of wickedness. This is Zalma's Insurance Fraud Letter, the source for the insurance fraud professional. Zalma's Insurance Fraud Letter continues its 28th year of publication, dedicated to those involved in reducing the effect of insurance fraud. ZIFL is published 24 times a year by Claim School and is written by me. It is provided free to anyone who visits the site set forth in this blog, and this issue contains some of the following articles, the full amount of which can be seen in Adobe PDF format at the link provided. First, an article about why, if you present as real a free and imaginary oral estimate as proof of a claim, will be considered fraud, and false swearing and fraud in a claim presentation voids the policy, and that is why you should never lie to your insurer about the extent of damage. Too many people believe that having a claim disputed by an insurance company is an invitation to get rich by suing an insurance company. People and some lawyers believe they can do anything to get money from an insurance company, to profit from a claim, even fraud. And if they're caught, they will still recover the true amount of the loss. So nothing is lost by cheating. The United States District Court in Illinois put the lie to that assumption, and an insured trying to inflate a claim with what turned out to be a false and non-existent bid was sufficient to make the insured take nothing, not his fraud, not even the legitimate part of his claim, and be ordered to pay back the insurer what was paid before the dispute. You can read the full article and the full issue of ZIFL at the link provided. Then there's an article about a criminal investigation of insurance fraud without an indictment is not grounds for the stay of a civil action, and why the Fraud Bureau's investigation of defendant Kith Furniture, LLC, moved to the proceedings brought by Liberty Mutual and Liberty Mutual versus Kith Furniture, and the district court resolved the dispute in favor of the insurer. You can read that full article and the entire issue of ZIFL at the link provided. Then we have more McClenny, Moseley, and Associates issues. This is ZIFL's 31st installment of the saga of McClenny, Moseley, and Associates and its problems with the federal courts in the state of Louisiana and what appears to be an effort to profit from what some magistrate and district judges indicate may be criminal conduct to profit from insurance claims relating to hurricane damage to the public in the state of Louisiana, starting with the May 24, 2024 decision in a case called David Wynn versus Southern Fidelity, where the alleged damage to Mr. Wynn's home in Louisiana during Hurricane Laura and Delta. Plaintiff, who was then represented by counsel from McClenny, Moseley, and Associates, filed suit in this court against Southern Fidelity Insurance Company, raising claims of breach of insurance contract in bad faith, only to find Southern Fidelity did not insure Mr. Wynn. You can read the full article and the full additional information about the actions of MMA at the link provided. Next, there's an article about a trucking firm owner's scheme to lower his insurance costs made him find that he was guilty on 7 counts. Tony Kierik, the owner of a New York trucking business who fabricated a supposedly independent Texas affiliate to circumvent his existing firm's negative safety rating, higher insurance costs, was found guilty of conspiracy and fraud, and on June 21, 2024, a jury in the U.S. District Court for the Western District of New York, following a 3-week jury trial, found him guilty on 7 counts that included conspiracy, false documents, false statements, falsification of records, and concealment of material facts, and he faces a long jail sentence. The next article is about the need for more prosecution to deter insurance fraud. And it is a story about Thomas Orville McLaughlin II, who was convicted of committing a fraudulent insurance act, making a false information, and interfering with law enforcement. He appealed, claiming several of the state's exhibits improperly admitted and that a defense witness was improperly excluded in a case called State of Kansas versus McLaughlin, the Court of Appeals of Kansas, June 21, 2024 decision, where McLaughlin sought relief from his conviction for insurance fraud and failed in that request. Next is a listing of health insurance fraud convictions, dozens of which start with the fact of Pacific Technology Laboratories, who agreed to pay $1 million to resolve allegations of fraudulent billing. Pacific Technology Laboratories agreed to pay the $1 million to resolve allegations that they submitted false claims for payment to Medicare for urine drug testing. You can read that full article and dozens more reports of convictions or settlements for healthcare providers. Then there is a set of articles about convictions of other than health insurance fraud, starting with the story of an Iowa woman who was sentenced for pet insurance fraud. Sarah Ram, age 39, of Bondurant, Iowa, made willful misrepresentations regarding her pet's medical history and then falsified the onset of a claimed medical condition in connection with an insurance claim, according to an investigation of the Iowa Insurance Division's Fraud Bureau. You can read the full article at the blog along with the full newsletter, Zalma's Insurance Fraud. Next, there's a story of why the United Kingdom in Britain convicted motorcycle fraud claimsters, where a person by the name of Matthew Shaw lost his claim in the UK in a case called Shaw versus Wild, a case that arose from a motorcycle accident that left Mr. Shaw with injuries to all 4 limbs. After receiving an interim payment of £150,000 from Hastings Direct, Mr. Shaw pursued £6.6 million claim, citing expenses for luxury vehicles and business class travel. Hastings Direct and Kios, achieved what is said to be the largest fundamental dishonesty verdict ever recorded in the UK, with £6.6 million saved by the insurance provider. You can read the full article and the full newsletter at the link provided. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can read the full Zalma's Insurance Fraud Letter at the link provided, and you can subscribe to the blog merely by clicking on and giving your email address at the place provided on the blog. And if you do, you will be given notice of every blog posting and every ZIFL publication, which are twice a month. And you can also subscribe to this video on rumble.com and on youtube.com and receive access to dozens more videos about insurance, insurance claims handling, and insurance fraud. And if you're interested in additional information about insurance, insurance law, insurance claims, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.